Dear friends, the Electricity Act 2003 paved the way of establishment of independent regulatory commissions. Independent regulatory commissions, the idea was to have professionals regulating the electricity sector so that it would be more transparent, more professional sort of entity. That was the ideology. Uh, so the Electricity Act, it established two levels of regulatory commissions. One, the central level, which is known as the Central Electricity Regulatory Commission, and the other at the state level, the State Electricity Regulatory Commission. The creation of both these entities, that is the Central Electricity Regulatory Commission at the central level and the State Electricity Regulatory Commission at the different state levels, that has to find its roots in these two acts which I mentioned. One is the Electricity Regulatory Commissions Act, which was passed in 1998, and then further Electricity Act 2003. So these two important acts, which are considered to be the acts which are responsible for changing the way the electricity is being produced and made available to the consumers, these two acts do matter in the discussion of regulatory commissions. So what is the CERC? As I said, the CERC is the Central Electricity Regulatory Commission, and it is a statutory body and under the section 76 of Electricity Act 2003, and it has lot of responsibilities. If you go to the website of CERC, you would find that they have listed n number of functions to be executed by CERC. But the most important function of CERC is to regulate the tariffs of the generation companies of Government of India. Now, as I said, the entire discussion of reforms, if it has to be understood, it has to be understood in the framework of economics. And setting the tariffs is an important part in the revenue generation of a company. So at what rate a generation company sets its tariffs, this was earlier decided by the government, the elected government in India. And now it was sought to distance the government from this function and place this function in the hands of an appointed body, which was meant to be an appointed body of professionals. It means that the elected government had no longer any say, direct say over the tariffs. It was now to be done professionally by independent experts of that domain. Now, whether this is a desirable feature or not could be debated, but one thing has to be noted down, that this system of separating the government from the tariff process was an important demand of the investors, the private investors who wanted to invest in the generation of the electricity. They wanted the tariffs to be regulated independently of the government. Okay, so they didn't want the government interference in the regulation of the tariff. So this commission, which is Central Electricity Regulatory Commission, this has been given the authority to regulate the tariff of generation companies of Government of India. Not only that, it had other functions, like it also was given the responsibility of regulating the tariffs of interstate generation, that is between the states, the generation, transmission and supply of power. Okay, so wherever the role of central bodies like central generation or central level distribution between the two states came into picture, the regulatory commission was the Central Electricity Regulatory Commission. And to grant license, to settle disputes, okay, At that level, it was the function of Central Electricity Regulatory Commission. So that is what is the Act's mandate. Act gives this responsibility, this mandate to CERC. CERC is a quasi-judicial body. It means that it has got certain very interesting powers to settle the disputes. Okay. So it can settle the disputes. People did not go to the courts. The investors did not go to the courts immediately. They can settle the disputes by approaching the regulatory commission. Okay, and just as we have the Central Electricity Regulatory Commission, at the state level, there has to be a State Electricity Regulatory Commission. So both the Central Electricity Regulatory Commission and the State Electricity Regulatory Commission, between them, perform many important functions. So they were empowered to regulate most aspects of the power sector. Means what? They decided the tariffs for generation, for transmission, for supply, as well as wheeling. They had the powers to grant license for transmission, license for distribution, as well as they could regulate the trading, electricity trading. They could adjudicate on the disputes which would arise between the various licenses and generation companies. So sort of court. And these regulatory commissions also have the power to suo motu on based on the petitions filed before them, initiate proceedings to hold the private licensees and institutions accountable for their statutory duties and responsibilities. So that is what it means of quasi-judicial status. These regulatory commissions, that is both the Central Regulatory Commission as well as the State Regulatory Commission, are responsible for different functions, including the legislative functions like notifying the regulations. They have a role to play in the executive functions, like implementing the rules and seeing that the rules are implemented, regulations are implemented. And as I was mentioning, the quasi-judicial functions like adjudicating on the disputes, seeing that there is a compliance with the norms, and if needed, to impose the penalties. Okay, so all in all, it was decided to have an institution with required checks and balances put in place. Okay, so that these institutions, they are accountable. Okay, and the Electricity Commission Act also set up another institution, called as Appellate Tribunal. Means suppose the licensees are unhappy with the decisions of regulatory commissions, then the Electricity Acts also set up the Appellate Tribunal for Electricity as a dedicated forum for appealing against the Electricity Regulatory Commission's orders. So if people are not happy, people means the investors are not happy with the orders of the regulatory commissions, then they can approach this tribunal, Appellate Tribunal, and if then still they are unhappy with that, then they can go to the courts instead of directly going to the respective high courts. Okay, so this in total is the contribution of the electricity reforms, that is the formation of regulatory commissions at the state level as well as central level. Another important achievement of sorts can be for the consumers. Okay. So for the first time, there was a consumer grievances redressal forum to be established by the distribution companies. So consumers, generally people who work in the state monopoly kind of structure, as consumers, they would always feel unhappy while dealing with the bureaucracy over that. So it was sought, this feature of addressing the grievances of the consumers was to be now given to an independent forum called as Consumer Grievances Redressal Forum, and this was compulsorily to be established by the distribution companies. Similarly, one can approach if the consumer is unhappy with the Consumer Grievances Redressal Forum, he can approach an electricity ombudsman, okay, which was to be established by electricity regulatory commissions. So these two features were meant to make the electricity sector more pro-consumer, especially for the genuine grievances which the consumers have. Another feature which has to be noted was the feature of allowing public participation in tariff setting. So every now and then you would find that if in the newspapers, whenever there is a tariff orders to be passed, there are notices put in the newspapers welcoming public participation or inviting objections from the general public regarding the tariffs which are being proposed by the utilities. Okay, so this feature was also is also designed to make this entire power sector more participatory. So this is all about the regulation aspect in the Electricity Act. Now, how do we look at it? So, looking at it from the angle of consumers, you would find that yes, the consumers have their voice, as in the Consumer Grievance Redressal Forum. They have their voice in the form of electricity ombudsman. Consumers also have their voice in the form of public participation in tariff setting. However, if we look at the policy direction, you will find that the consumers, especially the consumers who are at the lower end, the agricultural consumers, or the consumers who consume less electricity, in spite of all this, they would not be in a position to decide the tariff. Because the principle is to reduce, because the Electricity Act tells us that the cross subsidy has to be reduced. So this is going to favor the people who are consumers and high-paying consumers and who want reliable electricity and fast grievance redressal. Okay, so this is possible with this kind of system. However, for low-end consumers, in spite of these three distinguishing features of allowing the public to participate, the key issue of cross-subsidization is not taken care of. So the entire framework of regulatory commissions would facilitate the licenses, it would encourage private investments, and it would also create a hurdle for the state electricity companies, state-owned electricity companies, to decide the tariff as they please. So that the tariffs which they would be setting, that could be challenged, okay, in the tariff hearings by the consumers, by the consumer bodies at the regulatory commissions. And this is how it has been happening if you follow the debate of the electricity sector reform. So this is a very interesting aspect, the establishment of regulatory commissions and creation of bodies for appealing, for taking care of the grievances of the common consumers. Okay. Thank you very much. Bye for now.